part of this lecture material may be used without the express written consent of Rick Ramos or Contra Costa College. How you doing? This is Professor Rick Ramos, and we're continuing with our lecture series in criminal procedures. This is lecture number 7, and it's going to deal with the pretrial process and court structure. When I'm dealing with the court structure and the pretrial process, I'm going to use our local court structure here in Contra Costa County in Northern California. Now, there's a little bit of a history behind how the court system was set up within the last 20 years. But one thing has remained constant. We have what's called a dual court system. And what that means, there's two distinct court structures. There's the federal courts and the state courts. Now, when you're starting to look at the hierarchy of how the court system works, and in general, the basic theory of preemption, which means that certain courts have more power than others, you always go all the way up to the top, which is the U.S. Constitution is the highest law in the land. And then after that, it's federal law, and then it's state constitution, and then state law, and then local ordinances, county and city ordinances. Now, the same thing goes, similar structure when we're looking at the court system. The U.S. Supreme Court, of course, is going to be the highest court in the land. They're going to only deal with appeals, and below them is going to be Federal District Court of Appeals. And for the Western United States, this is District 9. This is pretty much everything west of the Mississippi, including Hawaii and Guam. And then below that, you have federal trial courts, and this is the criminal courts where the FBI, DEA, the IRS, they all do their business in this court, and they really are convicting people. It's a court that deals with the question of fact. Did somebody commit the crime or not? Now, that is a trial court, so it's kind of set to the side. If you look at my diagram in the PDF on Lecture 7, you'll see the Supreme Court at the top, the Federal District Court of Appeals, and then there's an offshoot, the federal trial courts. Now, below that would be the state Supreme Court, and that would be the highest state appellate court in California there in Sacramento. Below that would be the California District Court of Appeals. That's District 1 in San Francisco. And then below that, we would have the county level or state level trial courts. This one is located in Martinez for our county, and that's the Superior Court. And below that would be the lower county trial courts, including Bay Superior Court here in Richmond, California. So again, starting from the bottom now, Bay Court and Martinez Superior Court handle all of the trials that occur dealing with questions of whether or not somebody committed a crime in Contra Costa County. The people get convicted. At that point, it can go to the appellate process where they want to challenge, a procedure in the trial, or that some evidence was collected legally. Whatever it is, it's going to go up through the appellate process, and that would start with the District Court of Appeals. If it doesn't, satisfy the defendant, then it can go to the state Supreme Court. And then it's going to jump over the federal trial courts because it has nothing to do with them. It's going to go right to the Federal District Court of Appeals, and finally the U.S. Supreme Court. If you look at the chapter in the book, it'll pretty much explain what's going on there. I'm going to give you a little bit of history here, because on June 2nd of 1998, the voters of California approved a Senate Constitution amendment that allowed each county to abolish their municipal courts, leaving only the superior courts to hear all the civil and criminal matters, provided the judges in each county approved it. And the judges in most counties approved the consolidation within a year. The last county was Kings County, and it approved that process in January of 2001. So what used to happen was we had a municipal court which handled only the preliminary hearings for felonies, and it would handle misdemeanor jury trials, and then all felonies would go forward to Martinez Superior Court. That's all been eliminated so that all of the courts can hear, all the crimes that they want. The problem has been is that the legal structure and all the offices and the public defender's office, the DA's main office, are all located in Martinez, and so it really hasn't changed anything. They're still doing the work out in Martinez for serious criminal trials. So we're going to start to discuss the pretrial process, particularly the accusatory process, which is from arrest to trial or plea. This process starts with either an on-view warrantless arrest by an officer, law enforcement officer, or the service of an arrest warrant based upon a complaint or based upon an indictment from a grand jury. The suspect is brought in, they're usually booked into the jail, and at some point you're going to have to fill out an arrest record and a probable cause statement, which might be reviewed if it's a weekend or evening by a judge. You'll also have a group come in called usually an OR project that works for the court. They come in and they do a background investigation on the individual to determine if they're qualified for OR. They contact the judge, let them know what's happening. They might also be released on a citation, or they will be held until they go to court the next day. At the preliminary hearing, which is the first time they go, an initial hearing, and they may not have a preliminary hearing right away. They may actually have an initial hearing, which is really not named anything, because all they do at that is look over the case and set bail. And if the person can make bail, they're out of there, and they set a date for preliminary hearing. But the purpose of the preliminary hearing, though, is it's a device for screening cases before they go to trial. The purpose is to determine if there's reasonable grounds to believe that the defendant should be held to answer because a crime has been committed and it appears that they committed that crime. The preliminary hearings are usually held in Superior Court, may be assigned to any of the courts in the Superior Court system by the presiding judge of the Superior Court. A defendant may waive the right to a preliminary hearing, and this usually happens when they're going to strike a plea bargain with the district attorney. Usually they're going to be represented by an attorney, and that attorney will enter a plea of guilty and have the case bound over for sentencing in the higher court in Martinez in the case of Contra Costa County. Other things that occur in the preliminary hearing is that the evidence might be challenged. There's going to have to be sufficient cause to hold somebody over, and the defense will challenge the stop, the report of the officer, any seizure of evidence, and claim that it's in violation of the Fourth Amendment. And this is done under a 1538 hearing. The judge will listen to this, make a decision. If the stop's good, if the evidence collection was good, then the person, and it appears that the person committed the crime, and there's evidence corpus delicti of the crime, they'll bind the person over to Superior Court for trial. And then the person is either put into the custody of the sheriff awaiting trial, or they're going to be released on bail. Now, what happens at that point is the magistrate, the judge, will order the district attorney and the court clerk to prepare what's called an information. Now, if you look back in the Constitution, it says in the Bill of Rights that you have a right to know what you're being charged with. This is the piece that makes that valid and upholds that right. And it basically is a list of charges, count by count, of everything that the defendant will be charged with. So it'll say count 1, homicide, murder in the first degree. Count 2, kidnap. Count 3, possession of a deadly weapon. It'll have everything that the person's going to be hit with. Now, that information is for felonies. Very similar to a complaint. A complaint is basically for misdemeanors, and a citation is for infractions. Those are the different levels. Now, if it's coming from the grand jury, then it's going to be on what's called an indictment. It looks just like an information, but the way it gets there is different, and we'll talk about that a little bit later. On the information, it needs to have the name of the defendant, the name of the victim, the name of the court, and the description of charges. And as I said, they need to show each number or count against the person. Okay, let's briefly go over the grand jury process. So what happens is there's 19 jurors that are selected in Contra Costa County, and they meet in actually a secret session, and evidence is provided to them by the district attorney in the form of witness testimony and other real evidence. You need a majority vote to indict, and an indictment looks just like an information. Name of the defendant, victim, number of counts, and specific charges are listed. Once the indictment is issued, then the judge issues a warrant for the suspect's arrest, and once they're arrested, they become a defendant. Now the defendant who is arrested, they go directly to arraignment, where charges are read, and they enter a plea. So they don't need to have a preliminary hearing, because the grand jury process takes the place of the preliminary hearing. That's probably going to be a test question later on. The next step is arraignment. So whether or not they've been indicted and arrested on a warrant, or the judge has held them to answer in a preliminary hearing, An information or indictment is then read at the arraignment, the formal court appearance in which the charges against the defendant are read, and a plea is entered in response to the charges. Now, we have a variety of types of pleas that can be entered. The first, of course, is a guilty plea, meaning that you take full responsibility civilly and criminally for your actions. The next plea is a not guilty plea, and a not guilty plea says that you're innocent, that you didn't do it, and you're not taking any responsibility. A nolo contendere or no contest plea says that you will take criminal liability, but you will not take civil liability. And what I mean by that is you're basically never admitting you did it, you're just not fighting it, so that if you are working out a plea bargain and you get a lesser sentence or probation, and then somebody sues you for that same activity, let's say that it was a fight and you hit somebody and you pled out, you got a month incarceration and 6 months probation. When you get out, the guy sues you because you broke his teeth or something. When you go into civil court, they're going to have to prove that you did it, because in criminal court you never said you did it, and that's where people use that nolo contendere plea. The last plea is not guilty by reason of insanity. Now, if you use this and you're tried and you're found not guilty, then boom, that's it. Nothing further will happen. But if you are found guilty, then usually with the same jury, there's a separate trial to determine whether or not you were sane at the time the offense was committed. Now let's cover some technical information about arraignment. So arraignment, again, is before trial. The defendant is brought to the Superior Court, advised of the nature of charges against him or her. They are advised that they have the right to counsel at all stages of the proceedings, and they have a right to a trial by court or a right by a trial by jury, and they have the right to plead guilty or not guilty to charges. If the defendant is not mentally capable of entering a plea due to being intoxicated or under the influence of a drug or because of hysteria, the judge may set the arraignment over for 24 hours. If the defendant is still not able to enter a plea, then the judge is automatically going to enter a plea of not guilty. This means that the defendant will get to enjoy all of their rights. They're going to end up with a full trial, with a jury trial or a court trial, and they'll appoint a counsel for the defendant to make sure that their rights are observed. Now, defendants can be represented in absentia, which means they don't have to be there on misdemeanors. They can plead out, and they can even pay fines, or they can turn themselves in later for misdemeanors. But on felonies, they have to be present. When possible, the judge that issued the warrant for the arrest of the defendant would conduct the arraignment. Sometimes arraignments are out of court, such as a hospital or jail or other place when necessary due to the condition of the defendant. And a new trend is to use electronic arraignment, where there's two-way cameras with a computer, and you have the judge and the DA on one end, and you have the defense attorney and the defendant at the other end at maybe county jail in a special room that they use for this with cameras and microphones and such. And they conduct that arraignment that way. It doesn't necessarily have to be done live. If the defendant pleads guilty, the judge asks the prosecutor to advise the defendant of the aggravation of the case. If the person did something really bad to the victim, really injured them or something, they might look at the officer's police report to determine that. And if the report's not clear, the judge can set aside the case for 24 hours and subpoena the officer in to testify in court. The judge wants to know of the gravity of the actions of the person. Was it something that was really egregious, where they hurt somebody, put them in the hospital, disfigured them, whatever? Was it a rape or sexual assault? Something serious like that before they basically render a sentence. They want it to be a fair punishment for the crime. If the defendant pleads not guilty, the trial date is set by the court and subpoenas are issued for the officers and all the witnesses. They ask the defendant at that point whether or not they desire a jury trial or a court trial. And a court trial, as you know, is where the judge makes a decision as to guilt or innocence, and they inform the defendant of pertinent constitutional rights. After arraignment, if they're non-bailable, then the defendant is put in the custody of the sheriff, and they do a commitment order, and they're held for trial. Now, I have a flow chart, and it's going to show you, if you look in the PDF lecture notes, that it runs down really quickly how the accusatory process occurs. And so the first is arrest by police, they're taken to a magistrate within 48 hours, or facts on duty on weekends or holidays with the probable cause statement for arrest. Then they go to preliminary hearing where a judge decides whether they'll be held to answer. If they're held to answer and information is written up, and they go to arraignment, the information is read, and the defendant enters a plea. If the plea is not guilty, they go on to trial. If the plea is guilty, then they work out some sort of arrangements for sentencing. The other way that they could get there is grand jury hearing, followed by an indictment, and at that point, they skip the preliminary hearing and they go right to arraignment. And again, either the person works out a plea bargain or they decide to go to trial. The Constitution of the United States guarantees our right to speedy trial, and because of that, we have what's called a statute of limitations, and it's incorporated into all laws of all the states. It gives law enforcement the responsibility of taking immediate and continuous action upon a reported crime in order to identify the perpetrator so that he or she may be afforded a speedy trial. Statute of limitations in most states is as follows. For a misdemeanor, and this is in California, it's actually 1 year. For felonies, it can be 3 to 6 years, but for most felonies in California, it's 3 years. On murders or any death sentence penalty case or life sentence case, or a case where somebody stole public monies, there is no statute of limitations, and you can go after that person at any time. Now, we've covered what the district attorney and defense attorney's roles are in the accusatory process and trial. Let's look at what the judge is doing during the accusatory process and trial. In the pre-arrest phase, they review requests for and issue or deny search and arrest warrants. In the initial appearance, they advise the accused of constitutional rights, determine bail or pretrial release, and decide if the case should be dismissed. In the preliminary hearing, they evaluate the prosecution and defense's claims regarding probable cause. Then they decide whether or not there's evidence to hold the accused for arraignment. They rule on bail reduction requests and continue to advise the accused on their rights. At arraignment, they evaluate the indictment or information and advise the defendant as to a plea. They ensure the defendant understands the impact of a guilty plea or nolo contendere plea with regard to waiver of some of their rights. In pretrial, they rule on pretrial motions, and in the last lecture 6, part 2, we talked about all the pretrial motions that can occur, and they answer questions for continuances. In the trial hearing, if there's a not guilty plea, they set the stage for trial, and that must be within 60 days of arraignment. The defense can consent to a later date with good cause. It can be extended without consent of the defense, but within 60 days, they must start the trial process. We've already talked about pretrial motions. If you can go back to Chapter 6, and you can look up the motions, including to consolidate, to sever, and to sever, counts, to sever defendants, Kelly Fry, Pitchess motion, change of venue, quash inflammatory evidence, and compel exemplars. When someone is arrested and taken for booking, many times they'll try to make bail. And what bail is a sum of money specified by a judge to be posted as a condition of pretrial release that will be forfeited if the defendant does not appear in court for the scheduled hearing. At the court's discretion, bail may be increased or denied to ensure the safety of victims or witnesses. When you show up for court, you do get your money back. Before conviction, if the offense is bailable, the defendant may be admitted to bail for his appearance before the magistrate on the examination of charge before being held to answer. After conviction and upon appeal, if the appeal is from a judgment imposing a fine only, the fine can be posted as bail. If the judgment of imprisonment has been given, then the defendant will surrender themselves in execution of the judgment. When you show up, the bottom line is this, though. Okay, those are the times you can get bail. Typically, people go to a bail bonds person, and this is how it works. Let's say the bail is $100,000. If you go to a bail bonds person, you give them 10% or $10,000. They keep the $10,000. They post a bond for $100,000, and you show up to court. They get their money back. You don't get your $10,000 back. You have to sign over a home or other valuable commodity, jewelry, CD account, something to guarantee that you're going to show up. If you don't show up, they have skip tracers or bounty hunters that can come after you to try to capture you. And when you sign up for that bail bonds, you write off your Fourth Amendment rights, and you basically submit yourself to search or to being chased down by these individuals to get their money back out of you, because now they're liable for the full 100,000. But if you have cash, if you have 100,000 cash and you put it up for your bail, when you show up to court, the judge will then return the amount. Now, how do they set bail? Well, judges usually decide on the amount. Usually what happens is in the county, all the presiding judges get together and they decide on a bail schedule. Once you make an arrest, you look up the bail schedule for the amount that you'll charge the suspect, and then you fill out, when you're filling out your facts where you're establishing probable cause for the arrest, you also have a little area on there that you can either ask to decrease or increase the bail. If you're making the arrest, you're going through the motions, but you feel that this is a very weak case, or that the person has ties to the community and that they're not going to run, they're going to show up for court, you can ask the judge, using your best judgment, to lower the bail, and you need to write that in there. If you believe the person is a danger to the community or witnesses, and that if the person gets out, they're going to kill everybody related to this case, then you want to tell the judge that also, and the judge can increase the bail. Once they get into court, the judge works with the district attorney and defense to reach a settlement as far as what is the bail amount, and it's set by the seriousness of the offense, or again, that county bail schedule. There are a number of cases, the Martin case and Salerno case, that both talk about preventative detention, and that sometimes it's in the best interest of the community to keep somebody in custody because of the welfare of witnesses and or protection of evidence, because they may go out and destroy it. We'll talk a little bit about plea bargaining as it pertains to the criminal justice system. First of all, there's no way the system could survive without plea bargaining. It's just, the system, if you think about it, is like a funnel. And what happens when you push things down into the funnel? Eventually you could stop the funnel up, it'll stop. So without it, the system would be overburdened with cases. Plea bargaining leads to prompt and final dispositions in cases. It reduces times defendants will spend in jail awaiting trial, and it reduces the time that other defendants are out on bail if they're a danger to the community while they're out. So it really speeds the process up. I want you to know two different definitions. The first is explicit plea bargain, which is direct negotiation between the prosecution and the defense. And in explicit plea bargaining, the defendant agrees to plead guilty in exchange for lesser offenses. The next definition is implicit plea bargaining, and implicit means that they're going to enter a guilty plea with the unspoken but reasonable expectation of a less harsh sentence for saving the court time. What I mean by that is somebody really screwed up, and the district attorney has said they're going to give them some sort of a plea bargain, but it's such a heinous crime that they'll take whatever they can get. When defendants make plea bargains, there are some case laws that take effect. Number one, the Boykin in 1969 case says defendants must make an affirmative statement that they are voluntarily making a plea bargain. In other words, they have to cop out in court. And copping out is where the judge reads a series of questions to determine if they're pleading guilty voluntarily and if they understand all their rights and the fact that they're waiving all those rights. In Ricketts versus Adamson in 1987 says the defendants must uphold plea agreements or suffer consequences. And in that case, the defendant refused to testify at a murder trial after receiving a second-degree murder charge, and they went back and recharged him. In Alford versus North Carolina in 1970 says a plea of guilty may be accepted for the purposes of lesser sentence by a defendant who nonetheless maintains his or her innocence. So it doesn't say that you have to say that you're guilty. You can basically go nolo contendere, right? The next case is a Hayes case. Says the defendant's rights are not violated by a prosecutor who warns that refusal to accept a guilty plea will result in a harsher sentence. The other thing you need to realize is that not everybody's going to go to court, and I think I talked about PC 1000 diversion cases, and this is another way to deal with, it's another sort of plea bargain that could be struck. For first-time drug offenses, it's informal probation, can only be used on one time in a person's life, and it's possession for personal use of any drug or narcotic where you basically get diverted and get some counseling. And that's the end of lecture number 7 on the pretrial process. Please check the homework drop box, the exam schedule, and discussion assignments to see if you have any due dates that are coming up quickly. That's the end of this lecture, and thanks very much for listening.